Okay. Ms. Scanders for Fair and Transparent Elections is pleased to be able to bring this event to you, and is equally pleased to have each of you in attendance, and especially some of the members of the Michigan Legislature. I'd like to go over a few logistical matters for this event. First, your microphones have been muted until we get to the end of the presenter's remarks. We suggest that you go to the view setting in the upper top right corner of the Zoom screen and pick speaker view so that you will be seeing the individual solely who is speaking. Second, we're going to hold all questions and answer them in the conclusion of our presenter's remarks. You can open up the chat at any time and write down your questions as we go along. Everyone's questions will be visible to all participants to avoid duplicative questions. You are encouraged to keep the chat window up during the presentation so that you can be aware of the questions that have already been raised. We will address the first questions in the chat and work our way down as we go along. If we run out of time, we will get an email to you all with answers to the questions that we could not get to you. Finally, we would really like to receive feedback from you on this presentation. Robbie Duda from MIFTY will place in the chat the URL that you can use to reach that questionnaire. Okay, so first, our speakers for tonight are Terry Goddard. Terry is the leader of the Arizona Voters' Right to Know campaign and the AZ Arizona 2022 ballot measure 211. He's a veteran of elections for public office. He has served as the Secretary of State in Arizona. He's served as the Attorney General of Arizona, and he has served as the mayor of Phoenix. So he has firsthand experience in campaign finance and what it means. Our second speaker will be David Kolker. He's the Senior Counsel for Campaign Finance at the Campaign Legal Center in Washington, D.C. David has a lengthy tenure of 20 plus years working for the Federal Elections Commission and the Federal Communications Commission. He has represented the government and others in such famous election finance cases as Speech Now versus the FEC, McConnell versus the FEC, and the infamous Citizens United versus the FEC. And our last speaker is Aaron McKean, Legal Counsel for State and Local Reform at the Campaign Legal Center. Aaron has over 8 years working on various legislation, starting with being part of the Wisconsin Legislative Service Bureau. And in the order of our presentation, the first will be Mr. Goddard, who will basically fill you in on what went on and what it took to get this initiative on the ballot in Arizona. The second speaker will be David Kolker, who will talk about some of the particulars, both innovative and not, that built the backbone of this particular legislation, and what he believes and we believe its effect and impact can be. And then our third presenter, will be Aaron McKean, and he'll be talking about some high points about what's going on in other states. Now, one of the things that I wanted to make sure that we had a chance to talk about is, let's see, hang on a second. I want to make this do this, a little momentarily technical thing. Okay, so at any rate. So we talked about the presenters, but the thing I wanted to do real quickly here was to, for those who are not familiar with MIFTY, understand the context of why we're interested in this and why we're making this event possible. First, big special interest money is in the process of setting the themes of our elections and dominating campaign messaging. It also is determining our candidates for office, and is getting special consideration from our elected officials over us constituents. Election money sources are increasingly hiding their donors. That's a big focus for us. Some people call it dark money. We call it secret money. Also, we're concerned about the use by nonprofits, by elected officials in Michigan, as the press is now making evident, is enabling corruption. We're also focused on campaign finance information is far too difficult for voters to access. We also know, and just recently it was shown, that Open Secrets has identified over $4 million in foreign money that invaded Michigan's elections from 2018 to 2022. And we also feel that campaign violations must have meaningful consequences, and our friends at the Secretary of State need to have the necessary resources to really do effective enforcement. Tonight's focus is about the first and second bullet, the special interest money, and excuse the graphic mistake here, it includes also election money sources are increasingly hiding their donors. Yes, this presentation is a lot about dark money. So at any rate, at this point, I want to turn the presentation over to Terry Goddard. Let me release my
Okay,
screen.
thank you. Thank you, Hank.
Welcome.
I really appreciate the chance to speak to some Michiganders on this critical topic and hope that you can do something about it, as we have chosen to do in Arizona. I guess if I've got two takeaway thoughts about transparency and the fight against dark money, they're these. One, it's a very popular program. In passing petitions over 4 separate campaigns to try to get on the ballot, I never had one person come up to me and say, no, I'd really rather not know who it is that's paying for the ads that are trying to influence my vote. Nobody did that. And I certainly had a lot of opportunities for them to do it. And it was bipartisan in its support. This was not a Republican or Democrat or independent effort. It truly attracted folks from all around the political spectrum. And that was reflected in our ultimate election victory with 72%. Obviously, no one party, especially in highly divided Arizona, could come up with that kind of a rousing victory. And I think it probably should have been better. Our polling throughout the campaign showed seldom less than 90% favorable to our basic principle, which is that you should know who's paying for the ads that you're seeing wherever you see them, whether it's on social media or on television. And the last part is you need to hire or be associated with the Campaign Legal Center. They're going to speak more in this program, but they were our single most important ally, I thought, in the effort to get first on the ballot and then now to survive any legal challenges, because they understand the law in this area inside and out. And unfortunately, the law has to be defended. And I thought we gained dramatically from that association. So just a little bit of history. We started in 2016 with the first initiative to try to get on the ballot. That taught me a very important lesson, which is you should never try to do a campaign where you're supported by somebody who doesn't believe in what you're doing. When our major financial supporter found out we were trying to stop dark money, he promptly withdrew all financial contributions, and that was the end of that. In 2018, I thought we had enough signatures to qualify for a ballot initiative, but the Supreme Court disagreed. And for some technical reasons, we came just a little bit short. 2020, you all know what happened. We were ready to get on the ballot and COVID hit. And in Arizona, the law was that you have to have personal contact with somebody signing a petition. And so personal contact obviously meant exposure, and we felt we couldn't put our volunteers through that kind of an effort. And then in 2022, we finally put it all together, got on the ballot, survived the legal challenges, overcame Americans for Prosperity, who was our major funding of our opposition, and the Arizonans responded dramatically. So that's where we are. It was a very simple proposition that I know David Kolko will talk more about, but basically it required larger donations to say where they came from, what the original source was, not the last source, but the one who actually earned the money and then put it into the stream that ultimately ended up with a political ad. It applies only to advertising. So it's not everything that a 501c4 nonprofit may have. It's just the money that they use to try to persuade voters. And we have an enforcement mechanism called the Arizona Clean Elections Commission. We felt that that was the best way to go rather than to try to set up a whole new operation. We used one that was in operation today. So Hank, that's the overall scene of what we have in Arizona. We're very proud of it. We think we set a pretty high standard, and hopefully Michigan will see the light. And I do want to quote that famous political philosopher, James Carville, who, when we did a sequence with him, he looked at it, he read the proposition, he saw the results, and he said, and I won't try to imitate his accent, but he said, this is just good politics. Transparency works and sells, and Americans like it.
That's a very good thing. Thanks, Terry. Okay, so next up is David Kolker. And let's see, I think we need to release his mic, which, there we go. Go ahead,
I
David.
think you can probably hear me now.
Yes, sir.
All right. So I'm going to talk about two things. I'm going to go into some detail about what's actually in the new law, which is the Voters' Right to Know Act, or Prop 211, or I'll just call it the Act. And then I will talk a little bit about the court cases that have already been filed to try to kill it. And I will piggyback on something Terry said. Disclosure polls really, really well. We also helped a little bit in Alaska, and we've worked with another group called Voters' Right to Know. And disclosure usually polls at like 75 to 80% positive. So it is bipartisan. And the 72% in Arizona was just amazing. So congratulations to Terry. So what is different about this law from other disclosure laws? And Arizona is really the first in the nation to have what I consider a robust traceback statute. And what I mean, and Terry alluded to this, normally if the federal government or a state has a campaign finance disclosure law, if you are a political committee or if you're otherwise spending a lot of money on election ads, you may be required to report your donors. But if the last donor who gave to you was Americans for Apple Pie or Acme LLC, but the money really came from somebody else, the disclosure requirements become pretty meaningless. And in the wake of Citizens United, what happened was that opened the door for corporations to be used as front groups, either limited liability corporations or 501c4 groups who don't normally have to report their election spending. So dark money exploded after that decision in 2010. And the question was, well, how do we have real disclosure back to the source? And what I tell people is this statute is only complicated to comply with if you're doing complicated stuff to avoid disclosure, because it will really force you to trace back all the way to where the money was really earned. So when we say original money, what we mean is either personal income, like you earned it, your salary, whatever, maybe you inherited it, or business income. So if you're a business, it's I sold gasoline, I sold couches, whatever, bona fide business income, that's the original source. So that is the goal. And what is unique about this law as opposed to other efforts, and I will compare it just briefly, there's the Federal Disclose Act, which has been kicking around Congress, unfortunately unsuccessfully for several years. And it does require tracing back. It obviously hasn't become law yet at the federal level. But the idea of that is if you give money to a group that you know is going to spend it on elections, or they did in the last election cycle, or some other criteria, then we'll consider your money that has to be disclosed. And I will defend disclose if it becomes law, but I think Prop 211 is better. And what's unique about it is a notice and opt-out procedure. So if you're a covered person, that means you're the person who's actually spending a lot of money on election ads. And if you're a covered person, when donors give you money, you have to let them know that it might be used for spending on election ads. And they have an opportunity to opt out. And if they don't opt out, then it is considered traceable funds. That means it's funds that have to be kept track of and reported. But if they do opt out, you can keep the money, but you can't spend it on election ads. And we've made it very simple. You don't have to set up a separate organization. You don't have to set up a PAC. You don't even have to set up a separate bank account, but you have to have what are called transfer records to just keep track of money that nobody opted out on and can be spent on election ads, or money that people did opt out about. So you can spend it on rent or staff or whatever, but not on election ads. And what that does is it puts everybody on notice that they might be disclosed if they don't opt out. It gives donors some control. We thought that that would help narrow the reach of this, that it might even appeal to libertarians who want donors to have control. because suddenly you have a statute where you know, because you're warned by the spender that it might be spent on election ads, and you have a choice about how you give it. So that's the general framework for it. It does define election spending with the term campaign media spending, and it is pretty broad. It covers express advocacy, which means ads that explicitly call for somebody's election or defeat. It covers what are often known as electioneering communications. That is any ad that's run shortly before the election. If it mentions a candidate by name or otherwise identifies him or her, it counts as an election ad. It does include spending on ballot measure advocacy, which is something that's not regulated at the federal level. So if you're going to spend money to defeat or get Prop 211 or the next one enacted, ads like that count. And it does make explicit that subsidiary costs for those communications are included. So if you spend $50,000 shooting a video, and then you spend $10,000 to air it, whether it's on Facebook or TV, you have to include the $50,000 as part of the expenditure, even though you spent $50,000 on a videographer or planning the ad, and that $50,000 wasn't spent paying CBS. But it's still part of the expenditure for the public communication. And there's some ambiguity in some jurisdictions about whether that kind of expense is covered. We made it explicit. The law has very high thresholds. The idea here is, first of all, if you're just giving your own money to a group to spend on ads, you don't have to do anything. You don't have to report anything. But we didn't want to bother the system or individuals with relatively small donations. We're trying to shed light on big, serious money. So you don't become a covered person, that is somebody who has to file reports about your spending and about your donors, until you spend $50,000 in an election cycle on statewide campaigns or $25,000 on local or municipal elections. There's also a very high threshold for donor reporting. Until you as a donor give more than $5,000, you won't get reported, because we're just not that interested in that. But the way the traceback works is that the last contributor to the covered person, he or she's given that opt-out option. And if the last contributor does not opt out, that contributor has to tell the covered person where the money really came from. So if Hank is spending $100,000 on election ads in Michigan, he becomes a covered person. And if I'm going to give him $50,000 and I don't opt out, he's going to say to me, David, where did the $50,000 came from? And if I say I earned it, it was in my savings account, that's the end of it. But if I got it from Aaron, who got it from Terry, then I have to tell him that. I said, well, it's actually Terry's money, and he gave it to Aaron, and Aaron decided to give it to me, and I'm giving it to you. Then all those intermediaries are going to get reported. But Terry's going to be the one who's deemed the original source. And he's going to have to be disclosed by Hank in his disclosure report when he starts spending over $50,000. That Terry will be named as the original source of the money, as it was passed through Aaron and then me and then Hank. Now, why, you may ask, do we make me be the one to give all that information to Hank? And the answer is partially a practical one about a state's jurisdiction. A lot of this money gets laundered in other states. So if Hank is in Nebraska, but he's a company that wants to spend money on Michigan elections, and I'm sitting in New York, but Terry and Aaron are in Mexico and Arizona, New Mexico and Arizona, we weren't sure that the state of Michigan could actually assert jurisdiction directly over Terry. It's just too many steps back. But Hank is spending the money in Michigan, regardless of where he happens to live. So clearly he has enough contact in Michigan so that Michigan can go after him. And because Hank is notifying me that my $50,000 that I'm giving him may be spent in Michigan, then I'm on notice that my money that I'm passing on has this direct connection to Michigan elections. So we thought that it would be legal if challenged, for Michigan to assert jurisdiction over me and Hank, because we were closely enough related to what's going on in Michigan, and I was put on notice. So the way Prop 211 works is I, as that last major contributor, have the burden of revealing to Hank where the money really came from. And if I can't do it, then Hank can't spend it on campaign media spending. He can keep the money, but he'd be violating the disclosure requirements if he tries to spend it on election ads and doesn't reveal where it came from. The other thing that's built into this is a little bit of an attempt to stop people from gaming the system by disaggregating the money. So if I want to give Hank $50,000, but I divide it up into a dozen $4,000 checks that I route through different people. If I give more than $2,500 to anybody and it gets passed on to Hank, he has to add it all up. In other words, if I give Aaron $4,000 and Terry $4,000, and they give both of those to Hank, he's going to know that I actually gave $8,000 through two different intermediaries, and he has to aggregate that and report that he got $8,000 from me. There's also a catch-all provision in the act, which is based on the banking laws, which says that if you do anything to try to structure the way you give money to avoid the disclosure requirements, that in and of itself is a violation of the law. It's kind of a belt and suspenders approach. And then two other features of the law. I've talked so far about the reports that have to be given to the state government that Hank is going to have to give as the one who does the election spending. There is also a requirement that when Hank runs those ads, say on TV, he has to have a disclaimer on the ad that lists the top 3 donors who help pay for the ad. So he has to figure out at the time he runs the ad, okay, I've got $1 million in the bank. Who are the top 3 people that contributed to that nest egg that didn't opt out? And those 3 people have to be listed. So it might say, David Kolker, Aaron McKeon, and Terry Goddard helped pay for this message. And it literally says helped pay for. It doesn't mean that we necessarily approved it, but because we were the biggest donors who didn't opt out, and that money went to Hank, and we were the original sources, we're going to be put by name on those disclaimers. And finally, in terms of enforcing the act, anybody can file a complaint with the Arizona Clean Elections Commission saying, we think Kolker violated the law by doing something wrong, not reporting properly. And if the Clean Elections Commission doesn't go after me, the citizen who filed the complaint against me can actually sue the agency for not prosecuting properly. And the courts will look at that with a fresh eye. And if they decide that Arizona Clean Elections Commission should have gone after Kolker, but didn't, then the private citizen can sue me directly. Has to go through that administrative process first, but there is kind of a belt and suspenders approach to enforcement, where if the agency for some reason stops doing what it's supposed to do, citizens can have a private right of action. So that's kind of an overview of the act. Let me talk a little bit about what happened after it was enacted. We poked the bear. So we now have not one, not 2, but 3 lawsuits trying to kill this statute. We should be flattered, but it's created a lot of work. So the first case was filed in state court by 2 sort of conservative think tank types, public interest groups, Center for Arizona Policy and Freedom Enterprise Club. I may be Free Enterprise Program. I'm botching the name. Anyway, so they sued in Arizona State Court, and they have, for strategic reasons, I guess, are not relying on the First Amendment to the US Constitution. They're only relying on the Arizona Constitution's equivalent freedom of speech clause. I think they think that that might provide them greater protection as donors than the First Amendment of the federal Constitution. So that was the first case that was filed. And Campaign Legal Center Action is representing Terry's group, Voters' Right to Know, and I've been actively litigating. We moved to intervene because it was the government that was sued. They sued the Secretary of State and the Arizona Citizens Clean Elections Commission. The Arizona Attorney General intervened as a right to defend the statute, and we intervened to defend it as well. And by the way, we wrote into Prop 211 the fact that we have a right to intervene in these cases. So what happened was we filed a motion to dismiss, and I had a court argument several months ago, and the judge ruled in our favor. That was on what is called a facial challenge. The plaintiffs came in and said, this statute is so messed up and such an affront to the Arizona Constitution that you should just kill it. And we said, no, on its face, it's just fine, go away. And the judge basically agreed with us. But then they wanted a second bite at the apple, and they amended their complaint and they said, okay, you've ruled against us, you haven't struck down the whole statute, but we four plaintiffs are so especially injured by this that we get an exemption from having to obey the statute, even though you're saying it's still good law generally. And literally 4 hours ago, I had an oral argument before the same judge about this as-applied challenge. I think it went well. I don't think they have a very strong case, but it's getting dragged out. The second case was filed by no other than Americans for Prosperity, the king of dark money, who has been known through the years to funnel hundreds of thousands or millions of dollars through various groups before it's spent on elections, and they don't like disclosure. This is a straightforward case based on the US Constitution's First Amendment. It was filed in federal court. It has been fully briefed, I think, since October. We haven't heard boo from the judge. There's been no oral argument. There's been no decision. But that is the one that's pending, the second one that's pending. The third case was also filed in state court, and it was filed by the Speaker of the House of the Arizona Legislature and the President of the Senate of the Arizona Legislature. Now, Arizona has this very cool thing in their constitution called the Voter Protection Act, which says that if a new law is enacted by the people at the ballot box, the legislature can't kill it. If they want to amend it, they can do so only if they get a 3/4 supermajority of the legislature, and whatever amendments they make further the purposes of the Citizen Enact ballot measure, not just because they don't like it. Well, this is an enormously good protection for Prop 211. And I suspect that the leaders of the Arizona Congress legislature who don't like this statute knew they weren't going to be able to kill it because of the Voter Protection Act, which is a constitutional amendment to protect ballot measures. So they brought a case not based on freedom of speech or the First Amendment or the Arizona Constitution's freedom of speech clause, but on the theory that the power given to the Arizona Citizens Clean Elections Commission is so overdone and over-delegated authority that it violates the Arizona Constitution's requirement for separation of powers. I won't go into the detail on this. It's a pretty strained argument because they're sort of picking up on a couple of clauses in the act to suggest that the Citizens Clean Elections Commission could basically do whatever it wants. And the case kind of ignores the fact that the judiciary is still there to rein in this agency if it should ever go rogue. So that case is, they're being represented by very loquacious, litigious people. And we had an oral argument before the state court judge in that case a couple months ago, and he ruled in our favor, denying them a preliminary injunction. They have now appealed that to the Arizona Appellate Court. They have filed their initial papers. We have another month to respond. They're clearly seeking to get this to the Arizona Supreme Court as quickly as possible. And I gather from my colleagues in Arizona that these legislative leaders in general would like to destroy the administrative state. And this is just one agency among many that they might want to defang. So what's interesting about this third case is they're not actually challenging the traceback disclosure requirements on their face. They're saying because the agency was given too much power, the whole statute has to be killed. But they're not actually making a specific argument about anything wrong with the traceback requirements. So if there are any lawyers in the call, severability would become a huge issue, that even if the court were to find that the agency has too much power, we have an extremely strong argument that all that means is that the agency's power needs to get reined in, not that you would strike down the traceback requirements. So this one is probably going to be the first one to get to the Arizona Supreme Court, although in the context of a preliminary injunction. You may be wondering, will all of this go to the Supreme Court? I don't know. If we lose before the Arizona Supreme Court in the first case, based on the Arizona Constitution, not that I'm predicting that, but if that were to happen, the US Supreme Court might not bother with it because it would be on state law grounds. If we win, I don't know whether the court would bother taking it or not. I would hope not. The federal case will go to the Ninth Circuit, which is a pretty good circuit for us when that goes on appeal. I suspect we'll win before the Ninth Circuit, and I just don't know whether the Supreme Court would take the case. And the last case, based on separation of powers, that would be almost impossible to imagine the US Supreme Court taking it. So I don't really want to make any predictions, but that's my quickie read on how they might play out. And I will stop there.
Thank you, David. That was a great review, both in terms of the particulars as well as the wheels of justice. I have one question for you, and that is, my understanding of what you just said is that the state has not been enjoined. So are they working on implementing the ballot measure? Well, hang on, I gotta get your mic back. Where? Oh, wait a minute.
Okay, I'm back.
There we are.
The statute is fully enforced. I believe they've set up the website to report the contributions. The agency has issued some advisory opinions and some regulations. So there is no injunction stopping it from going ahead.
Wonderful. Thank you. Okay. Our next speaker is Aaron McKean, who is a colleague of David's and is going to give us a wider view of some of the stuff that is going on at the moment in the other states. And Aaron, there's your mic.
All right, I'm here. Thank you so much for that. I am excited to tell you about what's going on in the other states, because what basically happened in Arizona caused a lot of folks to take notice, right? And say, well, if Arizona is going to try to deal with the dark money problem and they have a solution for it, let's see what it looks like, and let's see if we can do it where we are. And what that's meant is there has been legislation introduced in other states, including Hawaii, Illinois, and in Maine, where just this past year, where there were committee hearings held, and even in Maine there was, and Hawaii actually, both bills passed at least one committee of their legislature. So what they did is they looked at the Arizona bill and said, we can make something similar, and we worked with them to develop legislation that could be introduced that would, basically adapt it for those states, right? Arizona, Terry and David and the folks in Arizona tailored that bill or the legislation for the state. And what we do with, folks in Hawaii and folks in Maine and folks in Illinois is work with them to figure out exactly, how would this work in our state? How can we make it work? Because sometimes those thresholds about disclosure, right, could be different. Something like $50,000 works for Arizona, but is that going to work in Illinois? Or is that going to work in Maine? Some of those places are smaller states, and you might not have that many $50,000 spenders, but you still have meaningful meaningful amounts of money being spent that should be traced back to its original source. And then the final point I want to highlight here is something that has been mentioned earlier, right? That this is bipartisan stuff. This is, appeals to folks across the aisle. In Hawaii and in Maine, or I'm sorry, in Hawaii and Illinois, the bills were introduced by Democrats, but supported across the board. And then in Maine, the bill was introduced by a Republican, and again, supported by a bipartisan group. And so I think we can really see, based on the success in Arizona, that there is some movement to actually try this in other places and see how we can turn this, laboratories of democracy into, a reality for traceback.
David, thank you very much. Okay, now we have come to the end of the prepared remarks, and this is the opportunity to present questions. Now, what I would like to do is to walk through some of the questions that are in the chat. When we get to the end of that, people can, I think we'll open up some of the mics, and I would suggest that folks raise their hand so we can recognize people. But let's start off with what's here. Let's see. And by the way, I do want to highlight once again that we have an evaluation on the web that we encourage everyone to give us some feedback on how this went. And it's one of the first messages out there from Robbie Duda. Okay, so Nancy Morgan from Virginia asks, a bill on disclosure on independent expenditures is currently in play in Virginia. The ACLU killed the bill in the House, but the Senate bill is still in play. And she gave us an example. I think she went on to ask it a little bit later, do you all have any understanding of what motivated the ACLU or have some notions of what it might be in terms of their opposition? We need to open up David's mic, and I think we need to open up Terry's as well.
The ACLU has a long history of being First Amendment absolutists. So if you buy the premise that having to disclose spending might chill your desire to spend, then they view it as an infringement on speech. Less of an infringement than a ban on spending, but still something that could chill your behavior. The ACLU used to be even more vocal about these laws. They've quieted down a little bit, but I guess not completely. But they are absolutists. So anything that could restrict speech or discourage speech to them is taboo.
And in
and
Arizona, we've required the disclosure for any contribution to a political candidate forever. I mean, it's practically back to statehood. And so the idea that there's a chilling going on is very hard to reconcile with our practice. And I personally don't believe that's the case. I had a major contributor to our effort who actually got on live television after we won the election and said, I'm the biggest contributor to X, Y, and Z, and I've never gotten a nasty phone call. Well, I thought that was a kind of an unwise thing for him to say, but he still didn't get any. So I think the argument that this is chilling, that this has a negative impact on politics is just wrongheaded. It has a positive impact because now people know and can evaluate an ad based upon who's paying for it.
And we're very vocal about the fact that we believe laws like this promote First Amendment values. The Supreme Court long ago recognized that disclosure might chill some people from donating, but they said it doesn't matter because there are compelling governmental interests that are good, that make these laws worthwhile and why we uphold them. But the First Amendment is based on the idea in large part as giving us the tools to have democratic participation. And what could be more important than having an informed electorate when they go to the ballot box? So we'd like to emphasize the First Amendment value of these disclosures.
And the judges in the challenges have really come down on that last point. They've been very supportive.
Okay, the next question that we've got is another one from Nancy from Virginia, and she's asking, and this may be more to you, Terry. I don't know. How did the resolution decide, or the ballot measure, decide that 50,000 was the floor for people having to report?
Well, I take some responsibility for that. I've had a few years in Arizona politics, and pretty much knew what a true grassroots campaign for legislator or even city council would amount to, and we tried to not include them, basically to say that there is a level of campaigning where it's truly bootstrapping, and they shouldn't be required to have extra disclosure. So that was where the 25 for local and 50 for statewide came from. So I wish I could say it was more scientific, but it was really based on a lot of experience in the trenches in Arizona. The $5,000 clearly was tied to the fact that at the time was the maximum contribution that could give an individual could give in Arizona. It's since been raised due to a progression of ideas that were in the disclosure statute, but we kept ours at 5,000. Pretty much marks what, at least in our state, was a maximum donor contribution. So we wanted to, as David said, we didn't want to go after a large number of smaller contributions. We wanted to get the ones that were really trying to move mountains, and that was 5,000 and above.
Okay, thank you. Another question is the opt-out considered a law or best practice?
Well, I guess both. I mean, in Arizona now, it is the law. It was written, it's baked into Prop 211, so it's now part of the Arizona statute. We believe it's best practice because it's both more fair and easier to defend. In the 3 litigations, people haven't really done much to challenge the donor notice and opt-out. I mean, they've tried to wave their hands about it a little bit. But basically, I think it's helped us argue that makes the law more narrowly tailored. That's kind of a technical term, the way the courts talk, that you want to regulate as little speech as possible. Make it as have the least burden for the benefits that you're going to get. So if there's a donor notice and opt-out, it gives the donors more control over whether they're going to be disclosed or not. And we think that adds to its narrow tailoring.
And I think it made a big difference in some of our support, because many 501c4s were in fact supportive. And they took comfort in the fact that if the money was spent on administration, if the money was spent on education, it did not get disclosed. It was only the part that bought political ads.
Right. Okay, next question is there a way for the general public to research online where the funds come from for certain advertising in Arizona?
Well, the information that's going to be reported will show up on the Arizona Citizens Clean Elections Commission website.
Okay.
And the Secretary of State.
Okay.
Okay. And they are there's a request for a link to the legislation. And if any of you have it handy, you could put it in the chat. If not, if David or Aaron will get that link to me, I will send it to all the
Hank,
people.
I sent in the chat, I put Terry's website, stopdarkmoney.com. And if you go there at the top, you can click on read the initiative to see the text of it, or you can click on FAQ if you want lots of detail about how the thing works.
Cool, thank you. Let's see. And we already talked about have other states taken this approach. And let's see. Nancy asks, in Alaska, there is not floor threshold, right? But donors have to disclose if contribution is above $2,000. Is that correct?
I believe it is correct that they used a $2,000 threshold. Alaska is a little unique in that even before their ballot measure requiring traceback, they required contributors, donors, to report donations that they give. Normally, it's in federal law and in most states, donors rarely have independent obligation to report their contributions. They are instead reported by the group that receives the money and then spends it on electioneering. So that pre-existed, that contributor reporting obligation pre-existed the ballot measure. So the disclosure just sort of piggybacked on that and didn't change it.
Okay.
The traceback was new, but the donor reporting obligation was already in the law.
Okay, let's see. There's, yeah, okay, I see it right there. Let's see, Prop 211, the traceback. Prop 211, does it equal the Arizona traceback law? The answer is yes. All right.
Yeah, I mean, people don't, to get grammatical on you, people don't like call it the Arizona traceback law. They call it either it's Voters' Right to Know Act, Prop 211, but colloquially, yes.
Okay. Let's see. Question is, are there FEC rules on opting out regarding independent expenditures disclosure in their 2022 ruling?
I'm not sure what that's referring to, but when Congress enacted the McCain-Feingold amendments in 2002, they created the concept of an electioneering communication. So those are ads that might not expressly advocate for somebody's election, but they're broadcast in the jurisdiction where the election is taking place, and they name a candidate in the run-up to the election. The statute has an option where if you segregate the money that you receive to be spent on electioneering communications, you only have to report that money if you're the spender. But that if you don't segregate the money, then you have to report all of the contributions you got over a certain amount. That's a little bit of an oversimplification because the commission did weird regs and then they've been challenged in court, and I'm not exactly sure where it now stands. But for independent expenditures, that's a term of art under federal law, which means ads that expressly advocate for or against election. It has to literally say vote for David or be almost as clear as that. And the reporting requirements are different for independent expenditures than for electioneering communications, just to make it confusing.
Of course. Okay. On the website that you provided, it says that the material is the proposed legislation. What the question is, was it enacted as written?
Yes. It was an up or down vote, so it doesn't get amended.
Jason Morgan, one of the state representatives in the Ann Arbor area, who is working on this topic, says he is acknowledging that they're working on legislation to shed light on dark money. So then he goes on to ask, how did you all handle the politics with this legislation, particularly with labor unions and environmental groups and others? And Terry's laughing. Okay.
Well, with great care. Our labor unions were all supportive the first couple of times through. In the last effort, they were not opposed. They never were opposed, but they were a little more cautious. I can't explain that completely, except that there were some cautions put out that this might deter donors to certain causes. I thought we did a pretty good job, and you've heard from David all the reasons why a 501c4, which is the market we're talking about, really shouldn't be concerned and needn't be concerned about this, especially if they're one that doesn't do a lot of overt political work. And so the politics were interesting. The Democratic Party supported us. The Republican did not, although we had many individual Republicans, especially in the business community, who were very supportive and very generous. So I get back to the point that it was not a partisan effort. Our legislature is divided just about right down the middle, but there's a one vote Republican majority in each house. And so every year there was a disclosure statute that was introduced, and it never got a committee hearing. And that was strictly because of partisan leadership. And so there was this kind of a difference, I think, between the Republican office holders currently in the legislature and the great majority of people and former elected officials. We had a number of the former governor who I ran against 30 years ago, Fife Symington, ended up being one of our strongest and most eloquent supporters of disclosure, and obviously a blue blood Republican if there ever was one. Our former county attorney, a strong Republican, was supportive. Our former Attorney General, Grant Woods, was one of our committee chairs. So we did, I think, a pretty good job on the politics to make sure that we spoke across the partisan lines, but that did not extend to our legislature. I know that the distinguished delegate will understand how those politics sometimes work. I never overcame the locked arms that were in our legislature.
Terry, if I could just add, in terms of the unions, one of the things that helps is that the definition of business income includes membership or union dues that don't exceed $5,000 from any one person in a calendar year. The concept here was that ordinary union dues paid by rank and file members, nobody really cares who those people are. They don't want to be considered contributors. It's much more important to know it came from the SEIU than it came from 50 SEIU members who each threw in a couple $1,000s in their union dues. So by saying that the first 5,000 in membership dues, if it's the Chamber of Commerce, or membership or union dues, if it's a union, first 5,000 is attributed to the organization and isn't attributed to the individuals who gave those dues. If you are in a jurisdiction where typical union dues might be $7,000 a year, you might want to make that higher if you want to cut a deal with the unions. And if you want to follow the protocol of Arizona, which is we don't really care about individual union members being reported. We just care that it's much more interesting for people to know that there was $100,000 given by a union. So that is a way to deal with the union dues issue.
And my memory was faulty. Our Central Labor Council supported the proposition in Maricopa County, the largest section of the state. Our state AFL was supportive, and a lot of individual unions separately did motions of support. So I'm grateful for a lot of union support.
We've got a
Thank you
question.
for that.
Okay.
Well, I just wanted to add that's sort of one of the challenges we've been trying to piece out is how to get through some of the politics. And it sounds like you guys were maybe not able to move through the legislature because I suspect because of that.
The donor collaborative, whatever you want to call it, the dark money group. I took the position, and you can quote me if it's helpful, that in our legislature, and especially in the majority in our legislature, they either had received dark money, hoped to receive it sometime in the future, or were really terrified that dark money would put an opponent into their primary. And the result was that we never got past. We had a lot of I say it's nonpartisan, and it was throughout the population, but in the legislature, it was not. It was Democrats supported it, and the Republicans did not.
Thank you.
But you don't get 72% just with Democrats or just with independents. You got to have both sides.
Yep, and that of course reflects the kind of polling that we've seen throughout the country. And the truth of the matter is, the percentage of people who say that this is an issue that must be addressed is continue to rise. The average is getting into the 80s. So, and it kind of makes sense in terms of what people are exposed to with each cycle of the election.
Well, in seriously divided Arizona, we polled it from 1916, to my knowledge, until today, and it's always been in the high 80s to the low 90s.
Interesting. Okay. In Virginia, a Republican senator said he doesn't support this approach because it's too easy to game the system. How do you convince him it isn't the case?
Well, for starters, it's infinitely better than what we have. You don't have to game the system right now.
Yeah, you just contribute.
You just have
the
to launder
election.
your money through an LLC.
Right.
So, nothing's perfect. Let me put it this way. The fact that we got 3 lawsuits trying to kill this thing within a few months suggests that the people who don't want to comply with it think it's hard to get around.
And,
Well,
and
the last-
I take some comfort from Montana's example, the only state where a legislature actually passed the transparency program. And that truly was bipartisan. It was a Democratic governor at the time, very Republican Senate and House. And what they've reported is that the efforts to sneak around the system, and theirs is not as robust as ours, but it's good, actually stopped when the time for mandatory disclosure hit under their laws. So they found that from a pure political perspective, people didn't try to game the system. And we think we've done a good job of trying to figure out ways they might do it and try to anticipate them.
And recall I mentioned in my presentation, there is a provision that's kind of a belt and suspenders thing that says if you try to structure your transaction, for example, like doling out your $100,000 and 100 $1,000 checks to evade the requirements of disclosure, that in and of itself is a violation because you're clearly doing it to game the system. And as I said, it was based on an analogous law that's been around for a long time in our federal banking laws.
Well, it's money laundering for a political result. And I think the fact that the money laundering statutes are used in this way is highly appropriate.
Yeah, I think money laundering generally rankles the American public. All right. I have 2 minutes after 8. And I think I want to thank the 3 presenters that we've had this evening. I think you all provided the kind of perspective that we need to understand in terms of how to go about this. I'm getting a lot of thank yous showing up here, which is totally earned. I would suggest for the folks who came onto the session, the reminders came out of my personal email. If you have other questions that you would like to have addressed, please send me an email and I will circulate it to these 3 gentlemen and we'll get you an answer. I'm speaking for them, but I think they'd be game for that. And then again, reminder to do the webinar, the address, or excuse me, the evaluation, and that's on the screen right now. And with that, I think we'll call it a wrap. And thank you, everybody, for being here and listening to what I feel was a very informative session. Thank you.
Thank you, Hank.
Okay, good luck, Michigan.
Thank you.
Nice. Everyone click on the evaluation before you leave.